The information provided on this show does not, and is not intended to, constitute legal advice. Instead, all information on this show is for general informational purposes only. The information provided is not a substitute for legal advice, and we recommend viewers consult an attorney for specific legal matters.
Welcome to Condo Craze and HOAs on our YouTube channel, and there we are. Eric looking a little plastic over there, and my hair isn't gray. What's going on?
It's like we looked at Medusa.
I love it. It's our bobbleheads. Those are so cool.
Brian had that made up, and look how great that looks.
Oh my God, it's so amazing. And Eric is board certified, not the little guy right here. This one is board certified in community association law, and he has law firms here in Fort Lauderdale and in Orlando. And we are here, of course, each week to answer all your calls and your chat questions. And any question you have that makes your life in a condominium or in HOA absolutely crazy nuts from 1 minute to the next, you can give us a call right here in the studio. And the number is 717-GLAZER-8. That's 717-GLAZER-8, 717-452-9378. Also visit us on our chat box there on our YouTube channel, which you're watching right now. And you can ask us a question there, and I think you want to ask our listeners, our viewers, a question.
Yeah, how about we throw this question out before we start? It's Memorial Day weekend, right? What's the right terminology? We want to wish everybody, you don't want to say this the wrong way. You want to wish everybody an enjoyable weekend, but it's not proper to say, for the obvious reasons,
Is it a
happy Memorial Day weekend. Yeah. So you want to preserve the dignity of the holiday. You certainly want to remember those who have passed. So what's the right terminology to tell the audience? Enjoy yourselves this Memorial Day weekend.
Have a nice Memorial.
Have a nice. I don't know. I don't know what the terminology is. So how about in the chat box? You tell us what's the right terminology. Let us know what's the right terminology to tell somebody. I don't know. Have a great rest of your weekend. Is that just the way to say it?
Yeah.
But I think there's a proper way to say it. Yeah, right. I remember as a as a child, excuse me, I was a big baseball fan. So what was Memorial Day always popular for? Memorial Day, for those baseball fans out there, Memorial Day doubleheaders.
Oh yes.
They would play two. Yeah, and in between games at Shea Stadium, they used to have banner days, so you were able to actually walk on the field if you made a nice big banner talking about the Mets. Yeah, at those times they were losing like 100 games. Well, they're doing that again, losing 100 games a year, but at those days it was fun, when baseball was really a lot of fun. Anyway, write in the chat box, what's the proper terminology about this weekend?
Yeah, wishing. How do we wish Memorial Day weekend upon people?
Right, exactly. Yeah. Okay, back to the show for a second. Hey, guess what?
What?
I think next week, you know what we're going to do with the show?
What?
Hold it live in the Bronx.
Oh, why not? That would be so much fun in the park.
I think
what was that park?
That would be great. I don't know the name of the park in the Bronx, but what happened in the Bronx that day?
It was magical.
Trust me what I'm telling you. That was an incredible day for, I'm not saying because it's Trump, it was an incredible day for a Republican. The last Republican to do that was Ronald Reagan, and it didn't go nearly as well for him as it went for Trump this past week. And it was magical, and there's obviously, the trick here is he's trying to appeal to the minority base, because if he gets another 10% of the minorities to switch, just think of how close states like Ohio were in Pennsylvania. So if he gets 10% of the black vote in Philadelphia to cross over, right, the black vote in Cleveland to cross over, he wins Pennsylvania, he wins Ohio, and that's it.
He may win New York, you don't know.
So the election's over. So, that's the strategy. Let's put it that way. And if we're going to judge it by the Bronx, wow, it seems to be working.
Yeah.
Right?
Yeah.
Pretty incredible.
Yeah, big time. So, by the way, don't forget you can follow us on Facebook, TikTok, Apple, and Spotify.
Yes,
and
absolutely.
What is the latest on the condo and HOA legislation that the governor is supposed to be signing?
Believe it or not, we had some movement this week.
Oh my God!
Yes,
Did he sign it?
It's not signed yet.
He did not sign the papers.
But Florida House Bill 1021, that's the new condo bill. In terms of that, nothing has changed. But the HOA bill has been presented to the governor at this point.
So he has it on his desk.
Yep, we're waiting for the governor's signature. Okay, so it could happen. The governor has 14 days to make this decision, and a couple of things he can do. He can veto it.
Yeah.
Right, we know that that can happen. He could sign it so that it would become law, or he can sit on it, and after 14 days, it becomes law anyway.
Okay, so he can do nothing and it still becomes
Right,
law. I
it
didn't know
still
that.
becomes law. So,
But the HOA law is kind of cool because it just lets people be happy in their HOA.
big changes,
right?
yes.
Hands
it's
off
basically
me.
a hands-off bill. That's exactly what it says.
So I see him signing that one.
Yes, I do. I think so. I can't look. The bills passed the legislature overwhelmingly, basically unanimously.
Yeah. It was, yeah.
So I can't see him doing anything else but signing this bill. But you know how things have been. I don't want to jinx myself,
A
right?
similar one was on Governor Scott's desk.
Exactly, and then pulled away.
Yeah,
so we will see. Let's get back to last week for a second. I want to thank Greg Waltz from Assured Partners for being a guest on the show. It was great to actually hear that there's finally potentially some good news when it comes to insurance, right?
Yes.
There's competition now back in the market down here. It's possible that the rates may be going down. And today we're going to talk about another major change. And this one comes for getting the financial records or getting the records, the official records of the association's condominium association from the records from the association. And it's a big change in the bill. And let me start with a hypothetical here. Suppose you ask for access to the association's records. They are never given to you. They're not given to you. But the association says, no, we gave them to you. They were, right? What do you do now? You know,
I go to the website.
Well, I suppose it's not up yet.
Okay.
Tell us what the new law says, though.
So in response to the written request?
Yeah, that's right. That's what the new law actually says.
so
It's for condos only, by the way.
Okay, and it's House Bill 1021, and it says, in response to a written request to inspect records, the association must simultaneously provide to the requestor a checklist of all the records made available for inspection and copying. The checklist must also identify any of the association's official records that were not made available to the requester.
Right. So we're talking about, you know, the checklist being given. So here, to state the obvious, the manager who's responding to this records request now, they would have on the left side of a form the type of record requested, and then a box on the right side, it would be checked if they provided it to you. And it wouldn't be checked if they didn't provide it to you.
But they gave you the form, Eric.
They gave which form are you talking about?
This one that you're telling me that their checklist.
Oh, well.
They gave me a checklist. We gave you the checklist that we gave you the records.
Checklist, yes, right. But they didn't give me the records. You know, so if they don't give you that form, they're in violation of the law now. So if you keep moving on.
And it's an official record.
That checklist, right? That checklist in and of itself now. Is an official record, meaning that any owner is entitled to say, I don't want to just see records that you've given. I want to see checklists that you've given out. Because it's possible, you know, some people think, well, some people get the records and I didn't get the records. So you could say, well, when Joe asked for the same records that I did, I want to see the checklist you gave him.
Okay.
Why does Joe's checklist say that you gave Joe the exact records I wanted, but you didn't give me the exact records that I asked for like Joe did?
But isn't all that moot if it's up on the website?
Yes.
Yeah.
Absolutely, I agree. That's why you and I both push for putting things up on our website. But
password protected.
Of course. But this checklist now is yet another thing that managers better know that they're responsible to do. That's why it's important. I think it's great. I love it when managers write in at the end of each week asking me questions about the show, because this is something big. This is something that they really better be careful about in keeping in touch with the law and make sure they're doing. If not, they can get in trouble for not filling out these checklists. So
what does in trouble mean?
In trouble means you can wind up losing your license. You can wind up getting penalized with the DVPR. So these checklists are, for failing to turn over. Again, why? Because these are official record forms themselves. It's not only the fact that they're required to make these records, but they're required to give them out when asked for. So if you don't do them, you're violating two different statutes.
Okay,
right.
Got it.
So managers, be careful. Let's see what our listeners think. Let's take our first break of the hour. Hey, what do you think about the bobblehead, right?
I love it.
Give us a call, 717-GLAZER-8. Again, 717-GLAZER-8. That's 717-452-9378. Or drop us a question or comment in the chat box on YouTube. We will be back right after this.
There are very large management companies, and there are very small management companies. And I think Affinity sits somewhere in the middle of that, where they are big enough to provide you with all of the back of the house services, the accounting, the infrastructure, the support systems, but small enough to be high touch.
We believe at Affinity that we do the 9 to 5 so that you don't have to do that.
Oh no, an unexpected leak. Jay, you know that's no way to solve a roof problem. Call Best Roofing. We solve roof problems.
We are DMI Paving and Seal Coating, Florida's parking lot experts. We specialize in asphalt paving and repair, including pothole repair, seal coating using JC7 or polytar, concrete curbs, ramps, and walkways, and striping and pavement marking, as well as ADA compliance. We service commercial properties, including homeowners associations, apartment communities, shopping malls, warehouses, stadiums and arenas, and more. Experience is worth more than anything in an industry like ours, and our staff has decades of it. We have specialized equipment for any job, regardless of size, saving you time and money. DMI has a reputable history. We have been in business since 1956. We serve the state of Florida from 6 locations. Let us bid on your next parking lot project.
For mitigation after a catastrophic event, building restoration, repair and remediation consulting, or Senate Bill 4D inspections, please visit rimkiss.com.
Welcome back to Condo Craze and HOAs. Here on our YouTube channel, Eric Glazer, Karen Curtis, he's board certified in Community Association Law, and Richard Middlemark says, happy and appreciative Memorial Day weekend.
Okay, that's one way to go. I like that.
Yeah.
Sure, absolutely.
He says, I'm happy for living in a great country and appreciative for those who fought and gave their lives to support us.
That is awesome. I'll stand by that every time. Absolutely.
Yeah.
Way to go, Rich. All right, how about we'll take another question from the chat box. Prayer Line says, please explain Senate Bill 4D as it relates to a single-story condo reserves and what's required, full reserves or partial. Okay, so the new laws regarding mandatory reserves, it does not apply to you if you're a single story. Does not apply to single-story condominiums. It does not apply to you if you're a two-story condominium. It only applies to you for reserves if you are a three-story condominium. So if you're under 3 stories, when you send out the budget every year, you still have to show the budget with fully funded reserves, but you have the opportunity to waive them.
What would you tell a single story? I would fund the reserves.
You think so?
Yeah.
Absolutely
Don't
fund
you
the
think
reserves.
so? Yeah.
I'm saying it sarcastically.
Yeah.
Of course
Oh.
you should still fund the reserves. Absolutely, because if you need a major repair, you want the money to be there. You don't want to have to pass a major special assessment. Of course, you could borrow. Just know that once you borrow, that loan's going to be on the books for a while. You know, for many, many years,
Right.
typically.
Right.
So, yes, start funding reserves. I don't want to fight with anybody anymore about it. The obvious is you should be funding a reserve
Yeah.
account, even though
But you
you're
don't have
under
to.
3 stories.
Right.
You don't have to. Start
you
putting away money
should.
for reserves. How about we go to our first caller of the day? Who do we got?
Let's go to Marie, I believe.
How are you, Marie?
Hello.
Good morning, Marie.
Hi, good morning. Hi. Okay, I have a question. A couple of weeks ago, you mentioned something about the board actually reporting or putting the Treasury report on the agenda. Is that like something mandatory? Our board never gets a Treasury report.
It's not mandatory, you know, to put it on the agenda. As a matter of fact, you'd be hard-pressed to find anything that requires you to put anything specific on an agenda, you know, at all. So there's nothing in the statutes where you can go to and says the following shall be on the agenda.
Had mentioned it. You had mentioned it the other one day. So
actually, I stand corrected. Hold on, hang on 1 second. The only way I stand corrected is there is a provision under the statute that can force something onto agenda, and I believe it's if 20% of the unit owners get together and say we want this on the agenda, and they serve it on the board, then the board must put it on the agenda. Other than that, you can't force something onto an agenda. Okay, back to your question.
Okay. And also, what would your thoughts be on how to handle board members who don't answer questions? Like, there's major construction going on in the community, major, and there's been no communication as to when something's going to be done and what to expect. And every time the residents ask questions, they say, "Oh, it's on the portal. It's on the portal." Well, the portal is horrible.
Right.
It's just poorly created. It's a horrible portal. You can't even find anything.
Right.
And things pop up that from 6 months ago, all of a sudden, the minutes are there from 6 months ago that you didn't see yesterday. But what are your thoughts on that? I mean,
it's funny.
It's just a bad indicating a bad board.
So I think I answered the question. I answered your question before you asked the question, which is I told you that if you get 20% of the people to sign a petition to put something on the agenda, it's on the agenda.
And you paid for that portal, by the
so
way.
get your 20% to say, excuse me, we want to talk about the construction project. Force it onto the agenda, and then they have to talk to you about it.
But what about the bad website?
The bad
that
website?
Should be fixed up.
You tell your management company to change it, see if they can change it.
You can't put that on the agenda?
Yes, you can put that on the agenda too. Absolutely.
Yeah.
Put a topic on the agenda
you're paying for this website.
Right.
And
that our website stinks. You can
sucks.
force that on too. Absolutely. Whatever you want.
Yeah.
Yeah. If the people get involved, if 20% want to ask.
We had a president that just controlled everything and only wanted to pay the property management company half time instead of full time. And so they became penny wise and pound foolish, because now when this big project ensued with roofing and all kinds of stuff, we have 2-year-old roofs or new roofs 2 years ago. We have 13 roof leaks.
Wow.
And now the management company says, I've been trying to get the repair guy out, but I just can't reach him.
Yeah.
And then she's not really trying very hard because she's only getting paid part-time to do so many hours per week. So in the meantime, the residents are suing the board, suing us now. So now we have fines, we have lawsuits, we're paying for lawsuits and lawyers' fees and all kinds of stuff.
Yeah.
So,
hold on. Once there's 13 leaks, I got to tell you, your lawyer should be involved, demanding that the roofing company that came out.
We can't get a name of the attorney who's taking care of our property. We can't find it on the portal.
Yeah,
How do we find it?
I don't know. Sometimes you can find out the name of the attorney by doing a Sunbiz search of the association, and oftentimes the attorney is listed as the registered agent for the corporation. So oftentimes you'll find that to be the case. Okay. All right. Who do we got next?
Thank you so much. All right. Thanks. Bye.
Sunbiz, S-U-N-B-I-Z.
S-U-N, sunbiz.org.
Okay.
That's right.
Next, let's go to Marvin.
Where's sunbiz.gov? I'm getting confused. Hey, Marvin, how are you?
Good, thank you. Our condo is having a turnover election next month, and I understand that the developer members are going to submit their resignations, and following the election, we'll have a new board.
Right.
My question is whether the newly elected board can go right into an organizational meeting following the election, or must it set an organizational meeting date and agenda?
So you got to look at the bylaws, right? The bylaws of the corporation. And the bylaws will have a section in there, guaranteed, that talks about when the organizational meeting must be held. And sometimes it will say that it's got to be held within 5 days of the annual meeting, within 10 days at the annual meeting. The answer to your question lies in the bylaws, my friend.
But if the notice of the election doesn't specify that there's going to be an organizational meeting, can it have one anyway?
No, it cannot, because the organizational meeting is a board of directors meeting, okay? So that board of directors meeting has to be published as a board of directors meeting. So typically when the annual meeting notice will go out, it will say, okay, we're going to have an annual meeting, and then immediately following the annual meeting, we're giving notice right now that there will be a board of directors meeting, the purpose of which is to elect the officers of the association. Answer your question?
And then if it wants to do other things, such as appoint committees, does that have to be on that notice?
Absolutely. Absolutely. It should be in the agenda, of course. Okay?
Right. Very good. Thank you very much.
You got it. Keep it going, Rob. Who do we got?
By the way,
yes,
I took your certification course in Tampa in February.
Oh, great.
And it was great.
Thank you so much. Glad you. Hey, look, before you go, now that you've taken it, do you think board education should be mandatory for board members?
Absolutely. I've taken it before when I was on other boards, and I intend to keep taking it.
Thank you
I'm an attorney, so
great. See that?
I understand the need.
Thank you so much. I really appreciate that. That's from an attorney. That's great.
And the February course goes toward the law, new law.
Exactly.
You're in.
There's just so much. When this gentleman attended it, he did learn the new laws that have been passed as well.
And then, but this qualifies him that he's taken the course.
Correct. Okay. He's good. Yeah. And now, so will the classes that are coming up, and we have the whole schedule is out too.
Oh, okay.
A little too early to start telling everybody, but let's just say September and October is going to be busy.
Okay.
Okay. A little summer break, if you don't mind.
Good. No problem. Do it.
Keep it going, Rob. Who do we got?
Let's go to Joe from Boynton Beach. He's got a question about
Joe. How are you?
Reserve funds.
Oh, reserve.
Good morning, Aaron and Eric. Joe from Boynton Beach.
How are you?
This question is replacement reserve. We have a replacement reserve. I'm sorry, and about 40 line items on it. It's a pooled reserve. Can the board repurpose so they can convert a tennis court to pickleball courts with that money?
So this is in an HOA, right?
Correct.
Okay, so you have pooled reserves
with line items,
right? With line items, and you want to convert a tennis court to pickleball courts. That's a whole other issue potentially in and of itself.
That's that's an alteration material.
But he's in an HOA, so it
right.
wouldn't be. The question is, and I keep looking, by the way, to see if there's any condo cases on whether or not conversion of a tennis court to a pickleball court is a material alteration. I haven't seen it yet.
Really?
Yeah, I've researched it a few times. It's not there yet. But here you have reserves that have been put aside for tennis courts. They want to use them to convert it to a pickleball court. Now, the reserve items, the reserve money that you put away is really, I'm just thinking out loud here, reserve money is to repair, right? To repair things that have gone wrong, to repair things that need replacement. This is a change. This is changing something that's not broken into simply another type of court. So there's a pretty good argument that no, the reserve funds shouldn't be used for that purpose, because you're not repairing something that's broken.
You're changing
you're changing something. So I would feel better if you got a vote of the community in order to do that, rather than the board making that decision themselves. Okay, I know I made half the people there angry.
I
But it is what it
appreciate
is.
that. And again, they called it repurposing the money, but I didn't think that would be allowed.
Right, exactly. That's how I feel about it. Okay?
Thank you for your time again.
Thanks, Joe.
Appreciate
What
it.
about the
Bye-bye.
people that like to play tennis?
Right. What about those people that
Yeah.
like to pay? Typically, they keep a tennis court somewhere.
Okay.
But since tennis seems to be going down in popularity,
It can't be both?
you can. You know, they're trying. A lot of associations are trying to still maintain a posture where you're catering still to some people that like to play tennis, but the overwhelming number of people in the community have now gone on
It's
to
just
pickleball.
easier for the older you get.
To play pickleball,
'cause it's
absolutely. How many people play tennis? And it's interesting. Same thing happens to golf.
Yeah.
It's very interesting. As goes Tiger Woods, so goes the popularity of golf in this
So
country.
now they want to turn the golf courses into putt-putts?
Right. Could
With
they do that?
windmills and
Right,
everything.
right. That would be fun too. And no, you can't use your reserves for that.
No, you can't.
All right, back to the phones. Who do we got?
Let's go to longtime caller Myra.
Myra, how are you, Myra?
How are you? Okay, so I have a question today about a vendor and the way he's billing. So I'm on the board. About the 1st of February, we hired a new landscape vendor, and we had ongoing irrigation problems. Our irrigation is 17 years old, and they were aware of that when they signed the contract. So we have, valves, sprinkler heads, and we call them, and they were coming out and determining what the problem was. They would give us a proposal, we would approve it, and they would fix it. Last month, we called them about an issue. They came out, and afterwards, they sent us an invoice for $150. Now, the board maintains that's not in the contract. There's no minimum number of times they're going to come before they start charging us. They just up and decided that they were coming too many times, and they're billing us $150 every time they come out.
Okay.
Can they do that?
Hey, listen, it goes by what did the parties agree on? What does your contract say?
Yeah.
Do you have a contract? Excuse me. Do you have a contract with them? And if so, what does that contract say? That's what it boils down to. Do you have a contract?
Okay. Yeah, we do, and there's nothing in there that says anything about it. And they started out coming out whenever we need them, and then they just decided, well, this is too much. We're not going to do it anymore. And after 3 months, all of a sudden they show up, and it's $150 to show up. Yeah, no, it's not in the contract. The contract says they will maintain the irrigation.
Maintain it.
No stipulation says how many times they have to come to do that.
But their
So
contract,
yeah.
but their problems are so overwhelming that they're like, no, forget that contract. It's too much. We can't do it. So they're charging you an extra
that's
$100.
it. They said we didn't realize, and they're telling us we're too far away. They knew where we were when they signed the contract. This has all just come up because, I think they thought it was going to be an easy, come cut the grass, and occasional, maybe an irrigation, and it's turning out to be a big. But that's too. To me, that's too bad. They signed the contract. I think they should have to wait till the contract expires and then renegotiate that $150.
Well, if your contract says what you think it says and what you're telling me it says, then you're 100% right.
They're in breach of contract.
Yeah, they're in breach of contract.
won't come unless
Sometimes
you
you
pay
just
them?
enter into a bad deal.
Yeah.
Right? You made a bad deal. That's your problem. By the way, there's a lot of case law out there that says it's not the court's job. It's never a court's job to get you out of a bad deal. So let's flip it on the other way around. Sometimes, or a lot of times, I should say, condominiums who don't have their attorney review the contract first.
Oh.
Right? They'll wind up in a very bad deal, right? And they'll say to me, Eric, can you get me out of this?
No.
And I'm like, well, let me see it. Well, Eric, it's a terrible, terrible deal, right? And I'll say, well, so what?
Yeah.
Here's case law that says specifically it's not a court's job to get you out of a bad deal. You signed a bad deal, that's on you. You should have had it reviewed first. So here, the same thing would apply to the company that potentially signed this bad deal for your sprinkler system. They signed a bad deal where they didn't realize what they got themselves into. Too bad, they're stuck with it, and your attorney should be telling them that they're stuck with it. And you better comply with the terms of the contract, or else you're getting sued. Okay?
Well, so my thinking is just don't pay the invoice, and then they could sue us, or they can terminate.
That's potential
we have a
too,
clause in their termination without cause with 30 days. But I'm not going to pay. I'm not going to pay them $150.
And I don't.
Want to see what you thought about
and
that.
I don't blame you, but why not keep them locked in on a contract that gives you a much better deal than them? You know?
Don't let it go.
Why not keep them there? Why let them out?
Yeah.
Okay. All right,
Well,
let's do this. Let's take our bottom of the hour break.
They're not that great at
They're
not that great at
I hear you.
anyway. I mean,
I hear you.
Yeah, we lost.
And then you got to worry
I
about
just wanted
them
to see if they could
deliberately
just
causing damage.
come in mid-contract and start billing us randomly.
Right.
And
Yeah,
apparently they can't.
No, they can't.
Yeah,
You were right.
Thank you.
Okay?
Okay.
Thanks for the call.
Thank you so much. Thank
You got it. Let's take our bottom of the hour break. Keep the calls coming in. 717-GLAZER-8. 717-GLAZER-8, or drop us a question on the Condo Craze and HOAs channel on YouTube. We'll be back right after this.
Is your condominium or HOA in need of accounting services? Look no further. Gerstel, Rosen & Goldenberg is one of South Florida's largest accounting and auditing firms, as recognized by the South Florida Business Journal, and is one of the few accounting firms uniquely specialized to provide accounting services to their growing condominium and homeowner association clientele throughout Florida. With primary offices in Aventura and Boca Raton, satellite offices in Naples and Orlando, and a professional staff of 65, Gerstel, Rosen & Goldenberg is prepared to meet the needs of any condominium or HOA in the state. The professionals at Gerstel, Rosen & Goldenberg also have experience working with timeshares, cooperatives, hotel condominiums, mixed-use buildings, and ancillary operations like restaurants, spas, and country clubs. Put their 25 years experience in your corner. Gerstel, Rosen & Goldenberg, 305-937-0116. That's 305-937-0116 or grgcpa.com.
Someday, you will need insurance. And for that day, you'll be glad you wrote down Insurco Insurance and Financial Services. Why? Because Insurco virtually insures everything. They're a full-line insurance agency that'll put together the best possible coverage and premium for almost anything. Need homeowners or condo insurance? Call Insurco. Need auto or motorcycle insurance? Call Insurco. How about golf cart insurance or trailer and RV insurance? Just call Insurco for a free quote. They're open every day. From renters insurance, officers and directors insurance, and personal liability umbrellas to all types of business insurance, boat insurance, cancer policies, life, health, and annuities. All you need is Insurco. Get a free quote. They service Dade, Broward, and Palm Beach. Speak English and Spanish. Insurco Insurance and Financial Services. It's the only name you need. Office at 14401 West Sunrise Boulevard in Sunrise, inside Edmore Chevrolet.
Call 954-846-1206. 954-846-1206. That's 954-846-1206.
All over the world, people have plumbing problems. These problems can be expensive and destructive to fix. Have you ever wondered if there was a way to take care of your plumbing problems without destruction and an outrageous price tag? Welcome to Pipelining Technologies, Inc., where we specialize in fixing your problems without demolition and minimum cutting by means of pipelining. Pipelining is the ability to take a pipe damaged by root intrusion or long-term deterioration and make it new. By means of inserting an epoxy-saturated liner into the pipe and allowing it to harden or cure, leaving behind a brand new pipe.
That sounds great. How can I get pipelining in my home, commercial building, or condominium?
Simply fill out our online contact form and a pipelining representative will get in touch with you in a timely fashion, or call us directly at 561-853-5463.
HOA's YouTube channel. Give us a call to ask Eric, who's board certified in Community Association Law, a question. 717-452-9378, or ask a question in the chat box. Some people do both.
Okay, so let's go to Google Far. His question is, what can we condominium do about a resident who throws bird food and nuts for squirrels. And believe me, this question, while it may sound nuts in and of itself, is a question that actually does come up every now and then.
Well, you had an answer. What was it?
Shoot them. No, can't do that. You can do that to the iguanas, apparently. And I had a question come up this week about whether or not someone can shoot Muscovy ducks.
Yeah, Muscovy ducks aren't protected.
Right, they're not protected,
actually
apparently.
Shoot it and grill it and eat it.
Oh my God. Well, I'd rather go out to Longhorn. Okay, next.
It's like the Wild West.
The question is, what do you do about it? So if that person is a nuisance, like any other nuisance in the community, right?
The squirrel's the nuisance.
Well, because of the fact that you're feeding the squirrels, right? That squirrels are bothering people in the community, right? Squirrels and other birds are defecating and causing disease and damage to the property, then yes, you can get an order from a judge if you had to, saying stop feeding the birds, stop feeding the squirrels, stop. Absolutely, no two ways about it. That's something that you would be able to get either from a court or from an arbitrator, depending upon what type of association you're in. So yes, these types of things happen. I've done it before with stop feeding the ducks, for example. Okay, so these things in fact do happen.
Or get a big alligator.
Oh, right, exactly.
That'll take care of everything.
Barry writes in, if a 2025 Sears Structural Integrity Reserve Study is prepared on October 15th, 2024, and by the way, you have to have it, you have to have your Sears done before 12/31/2024. So you have this done in October, and the association adopts a budget on 11/15/2024 without waiving the 2025 Sears. Okay, so they adopt the budget on 11/15, and they don't waive the Sears for 2025. Must the Sears funding start in 2025 or 2026? So my position is in 2025, you still have the right to waive the funding of reserves. So for 2025, you still have that right.
I wouldn't do it.
Based upon the way the question is worded, it says without waiving. Barry makes it clear, without waiving the reserves. So if they did not waive the reserves for 2025, then yes, it has to go in the 2025 budget. So if you want to waive, you better make sure you waive. If you don't waive, it's got to be in your 2025 budget. Good question. Back to the phones. Who do we got?
Let's go to Chris. Yeah, let's go to Chris.
Hey, Chris.
Where are you?
Hi.
Good morning.
Hi. Good morning.
How can
Got
we
a
help?
question for you.
Hey, Chris, where are you calling from?
I'm calling from Florida. I was a Florida resident.
Well, we know
I want to
Florida.
ask you a question on potential class action lawsuits for
Yes.
people that want to opt out of HOAs.
I don't know.
There's an article that
Yes.
was written October 30th of 23, HOA regulators captive to deep pockets of developers, property management industry, says critics. Here's my issue. I pay over $1,000 in fees. I've had deferred services for 6 years because of litigation. I've asked for a porch light to be replaced, was denied. I have wasp infestation on my unit that has not been really taken care of. I can get I have mandatory services that I do not get yet have to pay for. I can find nobody to go to mediation with me. I get the financial records, and the current president who wrote a letter last year that I have talked about misappropriation of funds, where I have found that $54,000 have been charged to the owners that may and should not have been charged to us. And I have a question on attorney fees for, let's say, over $30,000 in collection of assessments, non-judicial foreclosures. Once the money is recuperated, should that money be put back to the association funds? It's
Yes.
just yes or no.
Yes.
Okay.
Yeah.
I feel like I'm on a witness stand. I got to tell you, this is just yes or no.
Yes.
It used to be my show, remember?
Yeah. But the wasp thing, if you get anaphylactic shock and get hospitalized and they didn't fix the wasps.
You obviously have a lot of things. Hold on. Cut her off.
A lot of problems.
She obviously has a lot of problems, very angry person.
She feels better now that she's gotten
it
all out.
That's fine.
It's very cathartic.
That's fine, but you don't just say, yes or no answer. I think I determine the answers to the questions here, no? It's not, sometimes it's just, I don't think I've ever answered a question on this show with a yes or a no.
No.
Right? So calm down. She's obviously got a lot of things that she's upset about. She obviously, at least the way I'm hearing it, I don't know if she might have a problem with lawyers, but the obvious answer to her questions when you have so many things wrong like that, and she feels she's not getting the services, she feels that there's money missing, it's time to go get a lawyer, okay? And if you cannot afford an attorney, no, it's not a situation where one will be provided for you. That's not how it works. But if you get a bunch of people together who feel the same way you do, normally that group will chip in and get an attorney.
Well, she says she can't find someone to go to mediation with.
I don't know what that means, okay? But the bottom line is this: if you feel you've got all these things that are a problem in your community, right? You would think, right? You would think that a lot of people would feel the same way, right? And if they do, then fine. Get a bunch of people together, go hire a lawyer, and do it all together.
But Eric, if you've got an infestation of wasps and then the light outside your house isn't replaced and it's dark when you come in and you trip and fall?
Understand. Put these put these complaints in writing, send it over to your management company. You may want to do it certified mail, return receipt requested.
Because once you do that, then the board is on notice, and if something happens, they are individually liable.
With her, it seemed that there's not just one thing.
Yeah, I think she wanted to be heard.
And she's miserable about the whole concept of HOA living, period, right? That's why she started with, I want to get involved in this, the lawsuit, the class action lawsuit that she wants to be a part of, right? So she, to me, doesn't like the whole concept of HOA living. Again, but if there's things that are annoying you so much, it's probably annoying everybody else so much. And if it's not annoying anybody else,
then
it's just you, then you're the problem. Okay? So let's do this. Let's take our final break of the hour. Taking your calls, 717-GLAZER-8. Again, 717-GLAZER-8. Or drop us a question in the chat box on YouTube. Don't wait for the last second.
Please.
We're running out of time. We'll be back right after this.
Is your home or condo looking old, worn out, and in need of a fresh look? Then you need PD Painting to paint your property and make it look like new again. PD Painting will first properly prepare your home and condo and then use only the highest quality paint products. After many years in the painting industry, PD Painting has achieved a reputation for always delivering a reliable and professional finish. PD Painting is fully licensed and insured and offers a 7 to 10-year warranty. Their technicians are expert craftsmen. Let PD Painting handle all the details and then sit back and watch them restore your property and bring back that brand new look and feel. Need a service call? PD Painting will be there on the spot. Need financing? PD Painting can offer that too. Call PD Painting at 888-416-3204. Again, that's 888-416-3204. Go to the website pdpaintinginc.com. Need painting done in your home and community? Contact the experts at PD Painting.
This message is for anyone who has taken on the important responsibility of becoming an officer or director in a homeowner or condominium association. It is also for the management companies who work closely with these caring people to make sure things are done the right way. Hello, I'm Gil Pomar, South Florida Regional President for Center State Bank, now the second largest bank based in Florida. Our bank, Center State Bank, has an amazing team of professionals who are exclusively dedicated to the homeowner and condo association market. Your job is not easy. There are repairs and new projects that need financing. There are legal and social issues that need to be understood. There are also technology and servicing issues that your residents want to be improved. Why not choose a bank that knows this business backward and forward? Why not have a local banker who will meet with you face-to-face whenever it is convenient for you or your board? Center State Bank has over 2,000 associations as customers for a reason. Please give us a chance to earn your business. Call Terry Russo at 954-633-1666 to make it happen. Center State Bank is an equal housing lender and a member of the FDIC.
Need an insurance evaluation, audit, or quotation for your condo association or homeowners association? If so, then you need to speak with our insurance experts at Mack Waltz. We insure over 800 associations, and we are the clear leader in this marketplace. Mack Waltz has been in business since 1989. We write insurance on billions of dollars of property values. We are an independent insurance agency representing insurance companies which specialize in condo and HOA insurance. The staff at Mack Waltz works closely with board members and property managers and regularly attends association meetings to help educate the association about their insurance policies. To learn more about how Mack Waltz can save you money and improve your insurance program, call now 954-640-6225 and ask for Greg Waltz. 954-640-6225. Mack Waltz Insurance Group. Let us protect your association.
Welcome back to Condo Craze and HOAs. It's our final segment. Don't wait to the end to give us a call right here. And you can also ask Eric a question in the chat box. 717-452-9378. That is 717-GLAZER8 with a Z.
All right, who do we got, Rob?
Hang on 1 second. Let's see. We have Tony.
Tony, how are you? Where are you calling from?
Hi, I'm calling from Port Orange.
Okay, great. How can we help?
You were very helpful, Attorney Glazer, in getting election fraud settled in February, and I just wanted to say thank you for that. And I have a question.
Thank you so much. I appreciate it.
If a president and a board member sign a contract for renovations to a clubhouse, but the contractor does not sign the contract,
right,
and he acts upon the contract, even accepting the first two draws for work that he did do, but then he doesn't finish the work, he walks away, we have to pay extra. Who is to be held liable or accountable for that additional money?
This is
that had to be
good question.
This is a law school question.
This isn't a yes or no question.
No. Right. Should I just say yes or no to this one?
No.
Right. Exactly.
Wow, this
Sometimes
is a
just
sticky question.
So we have a written contract that only one of the parties signed, but the other party acted as if.
So?
My partner right now has a case, right? Very similar type of case with almost the exact same set of facts, believe it or not. And there is case law out there that says even though it's not signed, right? Even though the contract is not signed, where a party acted as if it was signed, right? And knew what the material terms of that contract were, they can be held to that they in fact signed the contract, and they are bound by the terms of that contract.
It's
believe
like
it or
the bill
not.
on the governor's desk. If he doesn't sign it, it becomes law. Right?
Little different,
Little
little different. But the answer to your question is yes. Could that contractor be bound by the contract?
If he accepted the money.
Yes. Did he accept any money?
Yeah,
That's
twice.
interesting too.
Twice
he got paid and took money?
Yes.
Is that what happened here?
Okay. Yes.
Oh, you know what? Then a very good argument that he's bound by the terms of that contract, because he acted as if that contract was in existence.
And cashed the check.
So, yes, he doesn't get to say, no, I didn't sign it. The joke's on you. That would be, the law tries to do the equitable thing here. And what's the equitable thing? The equitable thing would be to impose that contract on him because he acted as if that contract was in existence.
Okay, that's why I worded my question the way I did.
Excellent
and trust
question.
Me, you will be hearing from our HOA to get this case.
You
Trust
got it.
me.
Thank you so much, okay? Thanks for the comment to start the question. You got it. Who else we got?
Let's see. The next caller would be Martha.
Martha, how are you? Where are you calling from?
Hello?
Hey, Martha, how are you?
Hello?
Yes, you're there.
It's not Martha, it's Donata.
Donata, good morning, Donata. How are you?
That darn
Good
AI.
morning, Eric. I have two questions, Eric.
Yes.
One question is the following. I have requested a bunch of records and stuff like that from the board. Of course, that property manager that you know very well retired property manager. Of course, they didn't give it to me. I am not filing anything because I'm waiting for July the 1st. Will it count?
Well, when you say you're waiting for July the 1st, even prior to July the 1st, the association has an obligation to turn over the records to you when you ask for them. It's not like on July 1st there's going to be some new magical law that you're going to be able to rely on. Even before July 1st, you ask for the records in writing, they got to give you access to them within 10 days. Nothing changes after July 1st in that regard.
No, but but the laws are going to be way stricter. So I'm waiting for that. That's one thing. The other thing is they take like almost when they do not claim the mail. I have a lot of mails that they don't claim. They also take like forever to claim the mail. I have already filed a complaint with DBPR, which is being investigated,
right?
Because of $60,000. Can they do that?
No.
A long time without claiming the mail.
Yeah. So failing to claim the record will not get them off the hook. Okay, it happens all the time when attorneys also do like foreclosure work. All right, you have to send the first letter out a certain way, a second letter out by certified mail there, and oftentimes the defendant, the non-paying defendant, will not claim the records, the mail, because they know it's coming from an attorney. Does that mean that I could never foreclose on their home because they don't accept the mail? Of course not. So failing to go claim that certified mail is not going to get anybody off the hook from anything. Okay, that's the general answer to that question. Okay, back to the phones. Who do we got?
Let's go to Sam from Pinellas County.
Sam, how are you, Sam?
Yes, fine. I have a question for you. We have a maintenance contract on our roof, our condominium roof. But meanwhile, and that contract is for cleaning and inspecting the roof.
Yes.
Meanwhile, the last 18 months, our building has been under construction, and now it's coming to an end. And we had equipment that was on the roof, such as the swing stages, because we're painting and doing some construction.
Right.
So and also we had a contractor doing our repiping line. We now contracted the roofing person that's down in South Florida. He wants $8,000 first before he continues on maintenance, apparently because we did not do the maintenance the last couple of years.
Yeah.
Is this valid?
I don't know. I would have to see what the contract says, and I mean this, with the ultimate respect to our listeners, but sometimes you're asking me questions about a contract
you have to
that I haven't seen.
So
you're asking me a question about yes or no. You're asking me questions. I'm flattered. Don't get me, I'm the guru here. But sometimes I can't answer your question about a contract unless I see the contract. Can't answer a question about your docs unless I see your docs, right? So, difficult question to answer. But I guess this maintenance company is saying, wait a minute, first of all, how do you want me to do maintenance? Or maybe the maintenance that I have to do now on your roof is a lot different because the last year or so you've had heavy machinery on that roof. I don't even know what the roof looks like. You haven't let me see it in a while. So maybe that maintenance company feels they don't want to be part of that maintenance contract anymore because in effect you guys changed the circumstances for under which he was going to provide routine maintenance. Maybe it's not routine anymore after you put swing stations and heavy machinery up on that roof. Perhaps his argument is you guys changed this contract and he may have a potential claim there. Okay, that may make a lot of sense. So again, I don't know. I'd have to see what your contract says. But may they have a defense in that regard? Yes, they may. Back to the phones. Who do we got, Rob?
Next caller would be Joe from Fort Lauderdale.
Joe, how are you?
Eric, good morning. How are you, sir?
Good morning. How can we help?
I've got a question. I've heard different answers from different people regarding this. If you change your documents let's just say there's no more rentals, all right?
Right.
And you either don't sign it or you vote no. Does that apply to you, or does that not apply to you?
Okay, so this is a question that's probably going to lead us out. Okay, going to take us to the end. So
Can I say, wait,
yeah,
I would say it doesn't apply to you. No.
There's a long answer to this
Okay.
question. I mean,
So,
really.
no,
long,
yes or
but
no
you're
here.
right.
Okay.
Your answer, you're right. You're here long enough. You got the answer right.
But I'm not, I am
Okay.
15 years.
Right.
I better get it
but,
right.
But we got to tell everybody the story, how it got to where we are, because people are like flipped out that this is the law, okay?
Right.
So here's the law, okay? There's a case called Woodside versus Johnson, and it goes all the way back to the year 2000. What's the Woodside case about? Guy had 2 condominium units in a condominium on the west coast of Florida, and he was renting those condominiums out, I think it was for 18 years in a row. Okay, always had the pleasure of renting out the 2 units. Nobody ever bothered him. It was great. The people in that condominium said, well, we're tired of all these rentals. So they passed an amendment to the declaration that said from now on you could only lease your units, rent your units 9 months out of the year. So that killed him.
Yeah.
Basically, it made it impossible for him to rent his units. So he said, you can't do that to me after doing this for 18 years. I'm taking you to court.
Okay.
The case goes all the way to the Florida Supreme Court. And the Florida Supreme Court says, look, if 75% of the people in the condominium got together to amend their documents to say no more rentals, who are we to interfere with that? It's difficult to get 75% of people in a
Yes.
condo to agree on anything. So they want no more rentals. No more rentals, okay? So that was a devastating opinion to this guy. So one of the justices on the court at that time, Justice Kuintz, Q-U-I-N-C-E, she said, wait a minute, I agree with the decision we're making today, but hey, Florida legislature, this is devastating what happened to this guy.
Okay.
So what can you do to kind of make things better from this point on? So the Florida legislature said, okay, here's what we can do to make things better going forward. So from now on in a condominium, when the condominium wants to prevent rentals or shorten the amount of time that you're allowed to rent, things of that nature, it will not apply to those people who specifically do not vote in favor of it. Okay, so that's been the law for the longest time. So you get 75% of the people to say no more rentals in a condominium. It will not apply to the 25% of those that specifically did not vote in favor of it.
And what about
Okay.
moving forward, people moving in?
It then applies to them.
Oh,
Great question.
okay.
Now, when you sell your unit, it will automatically apply to anybody coming in.
Okay.
Okay? It will apply to
It
them.
won't roll over.
But it would. You don't get the benefit of the
Right.
rollover if you didn't vote for it. But again, if you didn't vote for it, it won't apply to you.
Okay.
So it's very important that when this is being voted upon, you keep track
You're
of how each
grandfathered
unit
in.
voted,
Right,
though.
yeah.
Very important to know that. Okay? So that's been the law in condos for the last 24 years or so. Now, the question always was, well, what about HOAs? Is it the same rule in HOAs where if you want to stop renting in an HOA, if the person doesn't vote for it, does it still apply to them? You know, and the question was always kind of left in the air, and that question's been answered. The HOA statute's been altered to mirror the condo statute,
Okay.
basically.
Okay.
So in an HOA, same thing. If the person if you're trying to pass this, if it passes, it does not apply to the person that doesn't specifically vote in favor of it. Same thing. However,
Oh, boy.
and I don't have the exact phrase in front of me, if you're trying to specifically do away with Airbnbs, so you're requiring a minimal rental term of at least 6 months, I believe it is, of at least 6 months, then that provision in your declaration, that amendment will apply to everybody regardless of whether or not you voted in favor for it
my God.
or not.
So the
complicated,
Airbnb
complicated set of law.
part of it,
right? The Airbnb part
sticks.
of it will stick.
So you don't
right.
grandfather on that one.
Right. So no matter what, if you're trying to prohibit rentals in its entirety, it doesn't apply to you in a condo and HOA, right? Unless you specifically voted in favor of it. But in an HOA, if you're trying to particularly limit the Airbnb situation, that will apply to you in your HOA regardless of whether or not you voted in favor of it.
Okay.
Complicated.
Yeah.
But that is the whole set of laws. That's
was-
the whole story as to why we have in Florida what we have. And it goes back
Woodside versus
Woodfide versus Johnson. Okay? And on that note, ladies and gentlemen, thank you for bringing us to the end of another week. It's an honor every Sunday for Karen and I to answer your questions. Enjoy the rest of your weekend. May it be meaningful, right?
Yes, yes.
And we'll see you and speak to you again next Sunday at 11 a.m. on Condo Craze and HOAs. Have a great and safe week, everybody.
Thanks, Eric.
Okay.